Hey, and welcome to Law and Society. Please subscribe. Today I'm going to talk to you about two consequential cases that have gone up to the Supreme Court, and in the next 10 days or so, these cases are going to be heard by the Supreme Court. First, on November 5th, is the Tariffs case. So it is Voss Selections versus Trump, and then there is the second smaller case is Learning Resources versus Trump. And both of these cases have been consolidated, and the Supreme Court has taken up the issue of whether the International Emergency Economic Powers Act authorizes the tariffs imposed by Donald Trump. And if IEPA authorizes the tariffs, whether the statute is unconstitutionally delegating legislative authority to the president. The lower courts, the Court of International Trade and the Circuit Court of Appeals for the Federal Circuit, ruled that IEPA does not give the president the power to tariff. It gives the president power to regulate. The courts held that regulate does not mean tariffs. And therefore, Donald Trump doesn't have the power to tariff under IEPA. Now, the Supreme Court has the choice of saying no, regulate means tariff, which would kind of go against Congress's powers to regulate commerce as well as to tariff. So those are two separate powers from Congress. And therefore, the question will come to whether IEPA, if it authorizes tariffs, meaning if it says regulate means tariff, whether it is unconstitutional because Congress has not specifically delegated to the president the power to tariff. The only way that Donald Trump could win the tariffs case is if the Supreme Court says IEPA remains valid and regulate means tariff, thereby encroaching on the legislative authority of Congress. So that's where the tariffs issue lies. That it is thus far, the tariffs are invalid because IEPA doesn't give the president the power to regulate, that IEPA gives president power to regulate and does not give power to tariff. Those are two separate powers under the Constitution's Article 1 power delegation to Congress. Now, the second case is about the temporary restraining order that came out of Illinois to stop the National Guard's deployment to Illinois. And it went up to the Seventh Circuit, and the Seventh Circuit Court of Appeals also decided that the temporary restraining order gets to remain in place because it is more likely than not on the merits that the government would fail to prove that Donald Trump has satisfied any provision of 10 U.S.C. 12406, Section 1, 2, or 3 in order for him to activate, federalize the National Guard. So in this regard, the question that the Supreme Court presents is whether the term regular forces refers to regular forces of the U.S. military, and if so, how that interpretation affects the operation of 10 U.S.C. 12406, Section 3. So, first of all, 10 U.S.C. 12406 is a statute that allows for the federalization of the National Guard of a state through the governor of the state or the commanding general of the D.C. Guard if it is in D.C. Now, the Supreme Court here is not asking anything about 12406 1 or 2, accepting the premise that the lower courts held that the government is unlikely to succeed on the merits, that there is an insurrection or there is a threat of an insurrection, or which is part 1 of 12406, or there is a fear or threat of rebellion, which is Section 2 of 12406. But Section 3 says if the president is unable to, by the use of his regular forces, execute the laws of the United States, he may then federalize the guard of that state through the governor. Well, there was an amicus brief, friend of the court brief that was filed, which talks about the meaning of regular forces. And it says that regular forces under American history and law has always meant the armed forces of the United States. And 12406.3's reference to regular forces refers to the direct armed forces of the United States. And if you have not deployed the armed forces of the United States as the precondition to then federalizing the National Guard, you have not met the precondition of federalizing the National Guard, and therefore the National Guard federalization is unconstitutional, not unconstitutional. It is violative of, it doesn't satisfy the statute. I'm not going to confuse it with constitutional interpretation. This case is about statute interpretation and the meaning of the word regular forces. And what happens if regular forces means it is the U.S. military? It means that Donald Trump made an error when he said in his filings that regular forces meant his DHS agents and other federal civil enforcement agents. But the amicus brief points out that it has never been the case that such federal agents have been considered regular forces under American law. And so the amicus brief's position is that Donald Trump's regime has been wrong in applying the meaning of regular forces and going and activating the federal guard of the states when he hasn't even deployed the regular forces, which under American law is the military. So, of course, the option here is going up to the Insurrection Act, and invoking the Insurrection Act would allow him to deploy the military onto American streets. And that is a scenario which is an exception to the Posse Comitatus Act, where the federal forces can perform law enforcement duties under the Insurrection Act. But the Insurrection Act requires threshold finding that there is an insurrection or there is threat of an insurrection. And we haven't reached that point yet. But mind you, Donald Trump is trying his best, and Stephen Miller is trying his best to use federal agents in ICE, border security, and DHS, other DHS agents to rile up crowds by conducting heinous, brutal detentions and renditions of people in neighborhoods, and thereby inciting protests that have largely remained peaceful, but they are shooting protesters with pepper balls. They are throwing tear gas canisters at protesters. And there's a case in that was ruled on in Illinois where the court barred federal agents from doing that. That case hasn't made it up to the Supreme Court yet. But in this case, what Donald Trump is doing is provoking and inciting and angering the community into being scared and then rising up to a point of conflict with federal agents. And when that happens, when he says that there is an atmosphere that there may be an insurrection or a rebellion against the United States, he will use that premise for the Insurrection Act and send the military in. But his deployment of National Guard here, in this case, falls apart if regular forces were to be considered armed military forces as it has been in American history. So these two cases are going to be heard by the Supreme Court. The tariffs case is a full case opinion that has come up, and the ruling will have an impact on all tariffs that have been applied under the law that Donald Trump invoked that delegated him the power, which is the International Emergency Economic Powers Act. And in the National Guard case that is coming up from Illinois, it is about the interpretation of regular forces, a statutory interpretation that what regular forces mean. This case, however, is currently in the pretrial stages, and this is an appeal by Donald Trump's regime to stay the lower court's temporary restraining order so the National Guard can be deployed into Illinois. The Supreme Court has not stayed the lower court's order, meaning the Supreme Court has not said that the National Guard can go on and patrol while we look at this case. In fact, the Supreme Court has said that we are going to look at the case and the meaning of regular forces before we allow the Guard to even go in. So there is a chance that, the way that these questions are presented are kind of difficult for John Sauer, who is a Solicitor General, to answer. Because in both these cases, in order for Donald Trump to win, it would mean that the statutory interpretation of both IEPA and 12406 must yield to what Donald Trump interprets them to mean. Donald Trump doesn't have the power. The president doesn't have the power to interpret what the law means. It is the power of the Supreme Court of the United States and the judiciary to say what the law is. That is Marbury versus Madison. And that has been how our government has operated for 200 odd years. So with that said, keep your eyes on the Supreme Court docket. There are going to be oral arguments. The November 5th argument probably starts at 9:30 in the morning. There is live audio feed on supremecourt.gov that you can go to. Or PBS and other channels are also going to stream, live stream the audio recording of this tariffs case, at least. If not, they're also the regular forces, National Guard temporary restraining order case. I think the second one will also be publicly available in recording. So with that said, keep your eyes on the courts. Keep your eyes on what the Supreme Court says. God knows how long it's going to take for the Supreme Court to rule on the tariffs case or to rule on the regular forces case. But by looking at the questions presented, I am leaning towards saying that the court is not going to go along with Donald Trump on either tariffs or the deployment of the National Guard. And that's going to have the plenary effect of the highest court of the land saying, no, Donald Trump cannot send in the National Guard on the basis of 10 U.S.C. 12406, and no, Donald Trump cannot tariff foreign countries under IEPA. Okay? I think I'm going around in circles now. So thank you for listening. Please like, share, and subscribe, and I'll talk to you soon.